Good evening, everyone. Welcome to Jnanavartini. We are having a moot court for the first time ever on Jnanavartini. And when I approached Meena ma'am to do a session, she was actually in a very hectic phase of her work. But she graciously accommodated my request and helped to take this forward. And then Tripti and Shruti Ruchika joined the team. And when we had the first discussion, I was so excited to be part of that discussion because they came up with so many wonderful ideas to make the session very interactive, enjoyable, especially for the people from the non-legal background. And rather than just presenting a judgment and debating about it, they came up with this idea of moot court. And I'm really, really looking forward to this session uh, because it was very exciting. That first meeting itself was very exciting. I'm sure all of you would be equally excited. And Ms. Meena Lal doesn't need an introduction in this group, but let me formally introduce her. Uh, Ms. Meena Lal is a gold medalist in LLB from Jabalpur University. She started her career in 1988 as a practicing advocate in the High Court of Madhya Pradesh at its principal bench at Jabalpur. In a short practice span of a year and a half, she was appointed amicus curiae in some cases by the High Court and also has to her credit few judgments in cases argued by her reported. Later, in 1990, she joined Tata Steel Limited as in-house counsel. In Tata Steel, she rose through the levels and has been heading the legal function at Tata Steel since 2008 in her current designation as Chief Legal, Industrial and Litigation. She has a rich experience in dealing with litigation in diverse fields of law, such as criminal, land, mining, environment, forest, labor, to name a few. She has the experience in the field of contracts of several kinds and dispute resolution. She's a keen learner and a passionate professional. She has contributed into volume 8 of a book series written by Mr. Samraditya Pal titled Constitution of India, Its Origins and Evolution. Welcome, Meena ma'am. Now I invite Ms. Reena Bengedi to introduce the other two panelists.
Thank you, Manju. And it's a privilege to introduce the key participants here. Ms. Ruchika D. Kumar, she is a principal associate at Krishna and Saurashtra Associates LLP. Her practice in areas include trademarks, copyrights, and designs. She has been a member of the Bar Council of Delhi since 2002 and has practiced before the Delhi High Court and other district courts. Her experience includes trademark and copyright litigation, trademark oppositions, trademark prosecution, copyright prosecution, and design prosecution. She has also handled appellate work in trademark matters before the Intellectual Property Appellate Board. She has previously worked in the trademark department of an IP boutique firm based in Singapore, gaining exposure to the trademark procedures in Singapore, Philippines, Malaysia, Myanmar, Brunei, Indonesia, and the USA. Ruchika holds a postgraduate diploma in cyber laws and cyber forensics from National Law School of India, University, Bangalore, a BA LLB from Delhi University, and postgraduate diploma in global sales and marketing management. She is also a certified personal data protection compliance auditor from FDPPI, as well as a DSCI certified privacy professional. Now, coming to Ms. Tripti Kumar, she is a general counsel of CMS IT, where she heads the legal compliance and privacy areas. Tripti brings with her more than a decade of experience working as a legal counsel in law firms and in-house. She is the president for the WICCI, Corporate Governance Council Karnataka. She has extensively worked with many clients in the general corporate law space, commercial contracts, labor and employment laws, data privacy and information security, legal due diligences, investments, transaction advisory, mergers and acquisitions, joint ventures, corporate restructuring, infrastructure, and litigation. Her multifaceted professional voyage includes working as a litigation counsel and corporate lawyer for a diverse portfolio of clients, operating across a broad spectrum of sectors, including banking, ITES, fintech, automobiles, pharmaceutical, defense, technology, real estate, healthcare, media and entertainment, infrastructure and education. Further, she has led complex negotiations and formulated and implemented compliance structures and processes and handheld various startup ventures. She also has been a part of internal committee under the Sexual Harassment Act, POSH, for various organizations and advisors on sensitivity and privacy related issues, policy related matters, and corporate governance. Tripti is a university rank holder in BA LLB honors and holds a master's degree in international business law. Welcome both of you, Tripti and Ruchika. Over to you.
Thank you, Reena. This session will not have any slides or any presentation, so I suggest you all switch to speaker view in your Zoom if possible. I'll hand over the proceedings now to Ms. Meena.
Manju, can we ask somebody like Abhay Warik just to spend 2 minutes on what is a moot court?
Meena ma'am is actually, it is part of...
Abhay Warik is there. See, there are many people here who are from the technology. They don't know what is a moot court. Moot court is an educational tool which is used. Okay, just 2 sentences. If Abhay is ready.
Abhay?
Otherwise,
use that typical legal language. Hajir ho.
Yeah, otherwise somebody else or even Meena Lal can actually start with that introduction of what is a moot court and then call the court to order.
Yeah, okay. Sure. Thank you, sir. Abhay, are you there? Would you like to take it up? I don't see.
I think Abhay is at work, so he probably will not be able to speak.
Okay, doesn't matter. So, good evening, everyone. Just a few sentences on moot court. It's actually in the colleges after I passed out. In fact, when I was also in college, there used to be moot courts, but not so prominent and frequent. But moot court is really a concept by which the student of law is given a feel of how the court functions. So mock courts are created. There are judges, there are lawyers on 2 sides. The students actually play the roles of lawyers, and problems are given to the students much in advance of the day of the competition, because the students are expected to research on the legal principles that would be involved in the case and present their arguments on the basis of the legal principles. Even before they present their arguments in the court, they have to prepare memos, what they call memos. So there is a petitioner's memo and there is a respondent's memo. So there will be a whole team supporting the petitioner's counsel, which will comprise of researchers also. So on both ends, there are teams involved, and these are competitions which happen at the national level. There are very famous moots, there are international moots, and students get a lot of opportunity to interact and do social networking with their student camaraderie right at the time when they are, before they've landed up in the profession. So it's really a tool, but it's a very, very engaging tool and a very hands-on experience that a student gets through the moot court. Now, we have today tried to create a view for all of you as to how a moot court could look like. This is a very, very nascent approach and the first beginning that we have made. Of course, this can evolve as we go along in the Gyanavardhini sessions and even in IDPS. So before we start, I would like to state that this is really a dramatical representation of a real case. The contents are not individual opinions. All participants are playing designated roles, and this entire session will be presented, as we said, as a moot court. For the benefit of non-lawyers in today's audience, moot courts are, as I already mentioned, staged as a mock case session where they are argued at both ends. Of course, we will be coming to you at the end of the session for hearing your verdict on the arguments presented by both the counsels. I will be presiding over this session as a judge and privileged to be so. Ruchika and Tripti will be the able lawyers presenting both sides as advocates on record. We request everybody to maintain the court decorum through the session, and we will take the questions also at the end, which normally the courts do not take, but we as a friendly moot court are open to taking questions also. So friends, come on now, order. The court is in session. The facts of the case, let's lay down the facts of the case. Because of the fact that a moot court has to be preceded by a problem. So this is the problem that I actually had given to Ruchika and Tripti. The problem goes like this. The French Data Protection Authority, which is actually called CNIL, they call it the commission. This is a commission. After now, we will call this as FDPA, that is French Data Protection Authority, found certain irregularities with compliances under its national law, which is the French privacy laws. The FDPA is being represented by our young counsel, Ms. Ruchika Kumar. One of the companies the FDPA found non-compliant with its national law is Facebook France and Facebook Ireland. Facebook France and Facebook Ireland are being represented by our counsel, by the counsel with us, that is Tripti Kumar. Facebook Ireland is the head office. Just to narrate the facts a little more, because that is when we will really be able to enjoy the arguments at both ends. Facebook Ireland is the head office for Facebook in the European region. Facebook Ireland and Facebook France are subsidiaries of Facebook Inc., now known as Meta Platforms Inc. in US. FDPA is placing reliance on GDPR and e-privacy directive, which has been included as part of French national laws. Further, to the FDPA committee deliberations to check compliances, the delegation carried out an online check on the website facebook.com. The purpose of this mission was to verify compliance by Facebook with the provisions of French Data Protection Act in connection with processing consisting of operations to read and or write information, that is cookies, in the terminal of users residing in France, particularly residing in France during their visit to the website facebook.com. It is also noted that Facebook Ireland was acting as data controller for the processing of personal data used in the context of the provision of the Facebook service to users in European region, including for the operations to write and read cookies on the website facebook.com. The entire controversy is around the website facebook.com and the cookies. The matter has been looked into by the restricted committee formed under FDPA, and now this session of the court is looking into the case being presented by both parties, after which this court will announce its decision on the issues placed before it. However, before we get into the arguments, it's important to understand what are the issues involved in the case. Issues is for our friends who are from a non-legal fraternity. I want to explain the issues really are the core point of dissent or dispute between the two parties. So therefore, the first issue that I place before the councils is freedom of consent and one-stop shop mechanism, French data protection law versus GDPR. How do you highlight this particular aspect? The Council for Facebook, please make your submissions on issue number 1.
Obliged, Your Honor, and with due regard to the brothers and sisters at the bar, appearing as counsel for Facebook. Just doing a mic check, I am audible, correct?
Yes, yes, you are.
Thank you, Your Honor. So my client Facebook admits the fact that Facebook Ireland was acting as the data controller for the processing of personal data used in the context of the provision of Facebook services to users in the European region, including the operations to read and write cookies on the website facebook.com. We dispute the competence of FDPA on the grounds that the alleged breach does not fall within the scope of the privacy of the e-privacy directive, which has been transposed into the French law. For the benefit of everybody, regulation applies to the whole of EU, whereas directives are absorbed by each member state separately. So GDPR is a regulation, whereas e-privacy is a directive. So the French law has absorbed the e-privacy directive, and they have now made it the French law. So when I'm using the terms French law, French national law, e-privacy directive, they're all synonymous as regards GDPR, for the benefit of the court as well, Your Honor. Unlike companies like Google and Amazon, which have been sanctioned by the restricted committee in the past for a breach of prohibition on placing cookies on users' computers without having first obtained their consent, the allegation in the subject case is that the rule has been breached, according to which it must be as easy for users to refuse the deposit of cookies as it is to consent to this. The issue is not taking consent or lack of consent. The issue here is degree of ease. I humbly submit, Your Honor, that this requirement of degree of ease does not arise under any statute or legislation. The law merely stipulates free consent. Where does it mention degree of ease regarding consent? This is a requirement rule created by FDPA, formalized in their internal deliberations, adopting guidelines, proposing practical procedures for ensuring compliances in the event of use of cookies and other tracers. I further humbly submit, Your Honor, that assuming that this rule actually exists, it could not materially fall within the scope of GDPR, as the FDPA partially acknowledges this by the posting on their website. The mere presence of a settings button, in addition to the accept all button, tends in practice to deter refusal and therefore does not allow compliance with the requirements under GDPR. Lastly, on this issue number 1, Your Honor, it is humbly submitted that it would be appropriate to apply the one-stop shop mechanism provided under GDPR to these proceedings. Under this mechanism, since Facebook Ireland, which is the data controller in question, is established in Ireland with its head office, as stated by Your Honor in the beginning, the supervisory authority competent to hear the facts alleged against it would not be FDPA, but the Irish Data Protection Authority. Also, a distinction should be made on one hand about operations consisting of depositing and reading cookies in a user's terminal, and on the other hand, the subsequent use made of the data generated by these cookies. In such event, the depositing and reading cookies in a user's terminal is being taken under French national law, and storage and subsequent use is being taken under GDPR, which is defeating the purpose of one-stop shop mechanism involving cross-border processing for companies like my client Facebook, which is present in over 30 countries. These are my submissions on issue 1, Your Honor.
Ms. Counsel, you have raised for the first time the point of jurisdiction, that FDPA does not have jurisdiction. Did you raise it earlier ever before? Because I don't find the point of jurisdiction raised in your pleadings.
Your Honor, it has been also accessed in issue number 2, but prior to that, the communication that was received to Ireland and Facebook France and Facebook Ireland, both of which are subsidiaries of Facebook USA. But admittedly, in the EU region, Facebook Ireland operates as the head office. And the humble submission here is that the French authority will not have jurisdiction over that because the action is against Facebook Ireland.
Okay. So basically, you want to challenge the authority itself of FDPA?
On the competence of the FDPA. Yes, Your Honor.
All right. Okay. Okay. The counsel for FDPA, I invite you to please present your counter on issue number 1.
Much obliged, Your Honor. Am I audible?
Yes. Yes, you are.
Myself appearing as counsel for FDPA. Your Lordship, FDPA is materially competent in accordance with the provisions to monitor and, where appropriate, sanction the operations of access to or deposit of information carried out by the company on the terminals of users of Facebook residing in France, And more specifically, the fact that Facebook fails to recognize the freedom of consent of internet users by not providing them the means of refusing operations to read and or write informations in their terminal that has the same degree of simplicity as the means provided for accepting their use. It is humbly submitted that each of these successive stages is subject to different legal rules. While reading and or writing operations are governed by special rules as laid down by the French national law of the e-privacy directive, subsequent processing will fall within the scope of GDPR and as such may be subject to a one-stop shop mechanism in the event that this involves a cross-border processing. In this particular case, the contention of FDPA is that that Facebook is not giving the same degree of ease to the customers of refusing cookies as it is giving them to for accepting the cookies. So we are not looking into any kind of trans-border processing or any processing that happens later on. It is restricted to what is happening on the French soil with the French users. Hence, the French law will be applicable. It is apparent that FDPA can insist on compliance under national laws to protect French residents to the extent of only the concern regarding reading and or writing operations carried out on terminals of users located in France using Facebook social network without making any reference to the subsequent processing. I humbly submit before you, Your Honor, that under the rules providing for relationship between the French national and GDPR, the provisions particularize and since the entry of GDPR are construed as reference to GDPR. This relationship between French national law and GDPR was also confirmed by the Court of Justice of European Union in earlier judgments. And it is further submitted that French national law for the specific obligations provides for its own mechanism for implementation and controls of its applications. The task for specifying the system of sanctions that they wish to implement to guarantee its effectiveness. All of this that is contained under the French law. So further GDPR enforces the fact that consent must be given freely, specifying that person must now have a genuine or free choice while consenting. With regard to operations of read and or write information, this reinforces the fact that consent must be freely given. It implies that the methods which are offered to the users to express their choice should be such that they do not encourage them to accept any more than it encourages them to refuse. So the mere presence of a setting button in addition to accept all button tends in practice to deter refusal and therefore does not allow compliance with the requirements laid down by GDPR and the FDPA. The FDPA also on its website had intended to highlight the enhancement of requirements relating to collecting users' consent before any operations to read and write in their terminals brought about by GDPR. So it was clearly stated on the website of FDPA that this there is an enhanced so I would like to read out what was stated on the website. It stated that the mere presence of a setting button in addition to accept all button tends in practice to deter refusal and therefore does not allow compliance with the requirements laid down by GDPR. So this posting was done on the website on 2nd of April 2021. So I would like to point out that GDPR does indeed support the conditions of consent, compliance with specific provisions resulting from e-privacy directive under the French law requiring such consent from the user before any operation to read and or write is now enhanced, and therefore French national law will prevail. I further submit that under Facebook Belgium case, it was held that in order to decide whether or not a case does in fact fall within the scope of GDPR, a national court ought to inquire about the exact source of legal obligation incumbent on an economic operator that is said to have been infringed. If the source of the obligation is not GDPR, then the procedures set out related to the substantive scope are logically not applicable either. Also, it would be materially impossible as the law currently stands to apply the one-stop shop mechanism to the facts under this case, as this position is also subject of consensus at the European level. So that is all I have to submit on issue number 1, Your Honor.
Can you give the citation of the Belgium case?
Yes, Your Honor, I will.
If you readily have.
Yes, Your Honor, I'll just send it to you.
Okay.
I will share it with you, Your Honor.
Sure, sure. Ms. Counsel, I want to understand if there is a conflict between e-privacy directive and GDPR, which one would prevail?
Lordship, in this case, GDPR in itself has made provision for member states to make laws which will be applicable to their users and their residents. So GDPR in itself has made provisions for laws specific to the member states, provided they have the same degree of I would say same degree of privacy and same degree of security afforded to the users. So in this case, the rule which is made by the French under the French directive is not something that is diluting the GDPR. However, on the other hand, it is an enhanced protection which is being given to the users. Hence, in this case, in our view, it is the French law that should prevail, and the French law will be applicable in this particular matter.
Okay. Okay. Let's now move on to issue number 2 that relates to territorial jurisdiction. A little while ago, when the counsel for Facebook was presenting her arguments, I did ask about the fact that whether the question of territorial jurisdiction has been raised in the pleadings at the first instance or not. Now that there is an issue which has been raised by Facebook, let's hear your arguments, Ms. Tripti, on behalf of Facebook. Okay. No, I would rather like to hear from FDPA, because the issue of jurisdiction needs to be answered by FDPA instead of first hearing the counsel for Facebook. So, Ms. Ruchika, I would invite you, and I would like to hear your arguments on territorial jurisdiction.
Much obliged, Your Honor, much obliged. Your Honor, FDPA is territorially competent in application of these provisions, since the processing subject to these proceedings, consisting of operation to access and or deposit information on the terminals of users residing in France when using Facebook, in particular for advertising purpose, is carried out in context of the activities of Facebook France, which constitutes establishment on French territory by Facebook Group. Now, for the purpose of for FDPA to have jurisdiction, there are two requirements which have been stated under the law, which must be met. Firstly, whether the company has an establishment on French territory, and secondly, whether processing in question is carried out in context of the activity of that establishment. Now, in this case, like I already said, Facebook France is established in the French territory. So that will constitute an establishment on French territory, and the processing, which is the read and or write operation, which is the access or deposit of information on terminals of users, which are in France, will be the context of activities of that establishment. So both these conditions are being fulfilled. So both are proven in this case, as Facebook is the establishment and it is targeting advertising towards French users. So hence the activities of the establishment, which is in France, hence this FDPA will be applicable, and FDPA does have territorial jurisdiction.
Okay. Okay. Counsel for Facebook, please present your arguments.
Much obliged, Your Honor. While activities and establishment have to be the two ingredients that must be established, the fact of the matter is, in global companies, given the verge of internet, the activities flow. And there is a reason, that is why there is a EU-wide regulation being put in place. To the extent that the rules of jurisdiction and cooperation procedures defined by GDPR should be applied in the current instance. FDPA would not have territorial jurisdiction to hear this case, since the real headquarters of the Facebook group in Europe, that is the place of its central administration within the meaning of GDPR as it falls, is located in Ireland. Facebook Ireland is admittedly the head office for the Europe region. Therefore, FDPA has no territorial jurisdiction. With presence in over 30 countries and global operations, a more wider applicable law like GDPR should be applied in the current instance, Your Honor. That's all on issue 2 of territorial jurisdiction, Your Honor, that FDPA shall not have competence since head office is Facebook Ireland.
Yeah, but Ms. Counsel, I would like to understand, how do you rebut the Google Spain judgment? Google Spain is a settled position in law.
Understandably, Your Honor, but that also has to be then demarcated as to how much of these activities that are being carried out are attributable to the French users. And that has not been done so by FDPA in the current case.
Okay. Okay.
Just by the mere presence of an establishment, assuming that there is activity being carried out, a penalty cannot be imposed without demarcating that that activity is enough to establish that French users are being put under the category of establishment of Facebook France, which is not the contention of FDPA. FDPA has sent notice to Facebook Ireland. So therefore, on the matter of territorial jurisdiction, if at all there is GDPR is not being considered, at the least the Irish Data Protection Authority must be chairing this, and not the FDPA, Your Honor.
Okay.
Lordship, I would just like to clarify here. The notice has been sent to Facebook France as well as Facebook Ireland. So whereby Facebook France and we had called upon both of them to ascertain who's the controller, and whereby Facebook Ireland has confirmed that they are the controller.
Yeah, the data controller. Yes, Your Honor.
However, they have an establishment in France as Facebook France, which is carrying out advertising activities and targeting French users. Hence, FDPA will apply.
But the demarcation of how much is attributable to French users has not been provided by FDPA, Your Honor.
Okay. Okay. Let's move on to issue number 3, which is related to unlawfulness of these proceedings. So, counsel for Facebook, please present your arguments.
I humbly submit at this stage, Your Honor, that my client did not at the outset, receive any formal notice, whereas 60 other parties were sent this notice of having formed the subject of corrective measures under French law for similar offenses.
So, was a common notice sent or separate notices were sent to 60 other parties?
Separate in our view, Your Honor, because the entities had to be identified as per territorial jurisdiction.
Have you put them on record?
Have we placed them on record? No, Your Honor.
Yes.
No, we have not, but this was an internal deliberation meeting by the restricted committee, Your Honor.
Okay. Okay.
But we have been given a hearing before the restricted committee to clarify this.
Okay.
And the resulting infringement of doing this, where notice had been sent to 60, but not to us, is where we are invoking the infringement of principle of equality, Your Honor. Even if there were, assuming that Facebook had made some error which had to be rectified and corrective action had to be taken, all the bodies which had to take corrective actions have to be treated at par in law. That is the principle of equality that has been laid out. It is an essential principle under EU law. Secondly, this principle is also not fully taken into account due to the severity of the corrective measures proposed by the FDPA in comparison with the recent decisions pronounced against other major stakeholders for non-compliance with French national law. The measures are too severe for the alleged breach. The breach is not, unlike in Google Spain, where there was a prohibition of placing cookies or there was no consent. The issue here is only the simplicity of refusing or accepting consent. The issue is not that there was no concept of consent. And Your Honor, therefore, the severity was not considered vis-a-vis the other 60 players. So there is an inequality that, has been brought to fore, and which is why we are pleading that there is unlawfulness to these proceedings, Your Honor. That's all on this issue, Your Honor.
Okay. Counsel for FDPA,
Your Honor,
please present your arguments on this point.
Your Honor, under the French law, FDPA may directly initiate a sanction procedure. It is not required of them to send a formal notice before initiating a sanction procedure against them. Further, in this case, a formal notice was even less justified since Facebook had already, following a prior formal notice, formed the subject of a sanction for breach relating to cookies in 2017. Facebook therefore needed to be particularly vigilant with regard to fulfillment of its obligations in terms of cookies and also attentive to the changes in regulation in this area. In particular, following the enhancing of the conditions of consent following the entry of GDPR. Now, we had already, FDPA had already pointed out that it will be carrying out checks on compliance within 6 months of its final adoption of the enhanced, of the action plan relating to cookies. And with respect to the fine, the amount of fine does not affect the lawfulness of the procedure. So just because in view of my learned friend, the fine is exorbitant, it does not mean that the procedure is unlawful. So they cannot question the procedure just on the basis of the amount of fine or the severity of the measures.
You mean to say that you are not bound or obligated to follow the principles of natural justice by issuing a separate notice to Facebook? Is that what?
Lordship, there was the commission had put in their observations. Response was called from by Facebook. It is not that principles of natural justice have not been complied with. There have been to and fro of responses between the rapporteur and Facebook, where the report has been shared with them. They have been given an opportunity of answering, which has been further answered by the rapporteur. So principles of natural justice have been complied with. It is not that they have not been given an opportunity to clarify their stands or clarify what they're doing.
Okay.
And they were already a proceeding against them. There were already sanctions in place. They were sanctioned in 2017. So as a company which is so renowned and has such tentacles all over the world, they should have been more diligent in the way they are operating. And their whole intention, I would say the way the company is operating, it seems that they are not very vigilant in taking care of the rights of French users.
Yeah, but I don't know how that absolves FDPA also of the procedural aspects.
Also, Your Honor,
sure.
Apologies for interjecting, but to be noted that the 2017 sanction which was given to us was pre-GDPR, Your Honor. So therefore, in light of that, now with the one-stop shop mechanism that is there, it has to be taken into account that global organizations, after a certain level, it is not possible for national laws requirements to be met. However, in this case, we have met it. We will look at it further down, Your Honor. We have submitted the screenshots for that, and those can be taken up. But now, which is good enough for what, when there is a prevailing regulation versus a national system, is where the jurisdictional issue has been placed before this court, Your Honor. Okay. But this is pre-GDPR, Your Honor, the first sanction that is being referred to in 2017.
So, well, we need to conclude this case today only. So, because thereafter I have my diary full. So let's move on to the next issue, which is breach of cookie obligations. Counsel for FDPA, may I invite you to present your arguments on this issue?
Thank you, much obliged. Your Honor, under the French national law, any subscriber or user of an electronic communication service must be informed in a clear and complete manner of two things. Firstly, the purpose of any action aimed at electronically accessing information already stored in their electronic communication terminal equipment or writing information to this equipment. Secondly, of how he or she can object to it. Now, when a user visits the social network Facebook, a pop-up window entitled Accept Facebook Cookies in this browser appears. And that at the bottom of this window, there are two buttons titled Manage Data Settings and Accept All. It was found that at this stage, no cookie was placed on the user's terminal, and that user was required to click on one of these two buttons in order to be able to continue browsing on the social network. In light of these findings, FDPA submits that Facebook had committed a breach of the FDPA as clarified by the enhanced requirements in terms of the consent laid down in the by GDPR, since it does not make available to users residing in France a method of freely consenting by refusing operations to read and or write information on their terminal, having the same degree of simplicity. I would stress here that the same degree of simplicity as the method envisaged for accepting their use. It is also submitted that the information provided to user does not allow them to clearly understand that they can refuse cookies. Also, when a user residing in France visits the website facebook.com, they can agree to the deposit of advertising cookies in a single action by clicking on the button accept cookies appearing on the first window. However, to refuse these cookies, the user will have to complete at least 3 actions. First, click on the manage data setting button located above the accept cookies button in the first window. Second, scroll down the entire content of the second window, in particular to establish that the 2 sliding buttons allowing the deposit of advertising cookies are disabled by default. And finally, by clicking on the accept all button located at the bottom of the second window. So hence, Facebook is not providing the same degree of ease to refuse cookies that they are providing to accept cookies. That is all, Your Honor, for this one.
Okay. Counsel for Facebook, please present your arguments on this issue.
Much obliged, Your Honor. It is humbly submitted that neither the e-privacy directive, which has been transposed into the French law, nor the GDPR or any of the rules provide according to which it must be easy to refuse cookies as it is to accept them. This rule is also not covered anywhere in the GDPR, which introduces only an obligation relating to withdrawal of consent. Which does not extend to initial refusal to consent to cookies. Therefore, there is no law which says that acceptance and refusal have to have the same degree or the same ease. It only says there has to be an option to withdraw or refuse consent. And those requirements have been met by Facebook. Further, the FDPA guidelines to which this reliance is being placed on are not mandatory, and they do not in any event refer to any binding provision of the GDPR or the national law or the e-privacy directive to which they refer to this rule mentioned. And these are brought under 2 instruments, which are mentioned under titles relating to refusal of consent and not to freedom of consent. So, Your Honor, currently there is freedom of consent. There is an option to refuse as well. The only issue is that there is the degree with which you can accept and the degree with which you can refuse are not same. But the law does not ask for that. The law does not stipulate that as on date, either in GDPR nor in the French national law. Lastly, Your Honor, the click path, which has been described in detail by my learned friend and counsel, has very clearly, it shows that it complies with the applicable rules, since it in fact indeed does provide from the first window information relating to cookie settings. And even that a distracted user who has reached the second window allowing these settings and clicks on accept cookies button at the bottom of the second window would not have any advertising cookie placed on their terminal. This is in line with the legal requirement, Your Honor. Simplicity of same degree for acceptance and refusal of consent has not been stipulated under French law or GDPR. The click path of the cookie settings are in line with the requirements set out under law as on date. That's all on this issue, Your Honor.
I just want to ask you, out of my curiosity, that the ease with which a user can accept cookies, can you not create technologically, is it not possible to create the same ease with which the user can say reject cookies?
Your Honor,
and why do you get into this kind of controversy? I mean, technically it should be possible for you, isn't it?
Because when you are rejecting, the options needed are higher so that there can be targeted advertising, which is a revenue generation. But having said that, there is an option. The law only stipulates the option. Neither advertising through targeted means is illegal under law, nor does it say that the degree has to be same, because acceptance is a blanket acceptance, whereas rejection has categories because it involves targeted revenue generation, Your Honor. It is a commercial call which makes more sense.
I understand. Yeah. I think Facebook is driven by the commercial call. That's what I'm hearing. Okay.
But within the framework of law, Your Honor.
Let's see. So moving on to issue number 5. Let's hear your arguments on corrective measures, publicity, and administrative fines. So, counsel for FDPA, if you may like to present your views on the fines and corrective measures.
Much obliged, Your Honor. Your Honor, Facebook follows a business model known as target content matching. operating both in the collection of data, their exploitation, and the operational implementation of advertisements posted in banners deployed within the social network. This update still does not put in place any means making it as easy to reject cookies as it is to accept cookies. So far, they have not taken any steps in spite of whatever deliberations have happened even prior to coming to you, whereby the report was given to them. This clearly shows that they have no intention of taking corrective actions to comply with the FDPA. So that's all that I need to say. Hence, huge amount of fine should be imposed on them, and action must be taken against them.
Okay, counsel for Facebook, defense arguments on the proposal of fines.
Your Honor, it is my humble submission that firstly, there is no definitive information or document which has been presented clearly identifying the profit made by the Facebook group from the collection and analysis of the cookies on the French market via the revenues generated by the said targeted advertising aimed at French users in France. Secondly, the law itself does not allow for the degree of acceptance and refusal to be same, neither the national law nor the GDPR. For the purposes of breach of French law is being considered with the gravity of infringement. The ease of refusal of consent for cookies is not same as no free consent, Your Honor. Further, we have provided screenshots of the update of our cookie consent collection interface rolled out in the European region, pursuant to the prior initial notice that we had received from the internal committee on this matter, including in the region of France. Given the nature of the subject matter, we humbly request that the decision not be made public as no serious harm is being caused to the public and the breach has been rectified. Facebook declares its intention in its statement that a targeted advertising model is a commercial model for Facebook. It is a commercial business organization. But how has it harmed the interest of the users on the French soil? No document and no demarcation of such revenue generation has also been submitted. But the fines, so therefore, how will the proportionality of the fines even be justified in the current case, Your Honor? And in what way has it hurt, apart from the jurisdictional issues already been placed before your court? The public has not been hurt. There has been no misuse of the public information. The consent policy is also in line with GDPR. It is just that this degree of ease, but degree of ease is not a stipulation of the law as it stands today, Your Honor. That is my humble submission on this issue, Your Honor. I rest my case with this, Your Honor.
Okay. So, thank you for making your submissions. Importantly, you have given not only the assistance to the court today, but you have submitted your submissions in writing. I have gone through the written submissions, and on the basis of your written